Welcome to your Euro patent brief journey with Bersha Tale. Today we'll be tackling some complex yet fundamental European patent law scenarios in EQE paper D1-2022. We'll go through the questions, analyzing the legal principles at play rather than just delivering the answers. That way you'll gain a deeper understanding of how the law works in practice. Patent law can feel overwhelming, but don't worry. I'll guide you step by step, making sure we focus on the key concepts. Ready? Let's dive in.
Question 1. Re-establishment of rights. Scenario. European Patent Application (EPF) was filed in January 2017 by applicant F. The EPO issued a communication under Article 94.3 EPC dated 1 September 2020, setting a 4-month deadline. Applicant F, however, took no action. No response was filed and no fees were paid. As a result, on the 4th of March 2021, the EPO sent a Rule 112.1 EPC communication, notifying the applicant of a loss of rights. However, applicant F only became aware of this loss on the 3rd of February 2022. Despite exercising all due care, the applicant had missed all previous deadlines. Now, how can applicant F continue the prosecution of EPF? What steps must be taken and by when? Concept breakdown.
The key issue here is re-establishment of rights under Article 122 EPC. Normally, when a deadline is missed, further processing under Article 121 EPC is an option. But here, it's already too late. The applicant needs to show they exercised all due care and file a request for re-establishment. But when does the time limit start? It's counted from the moment the applicant becomes aware of the missed deadline. In this case, 3 February 2022. The deadline? 2 months from that date, so 4th April 2022, considering EPC's extension rules. The applicant also needs to pay renewal fees for the 5th and 6th years, since they became due after the loss of rights.
Reflection.
This case teaches us that sometimes procedural remedies stack on top of each other. Missing a deadline isn't always the end of the road, but knowing which remedy applies and when is crucial.
Question 2. Correction of a granted claim. Scenario. Applicant B filed a European Patent Application, EPB, in February 2019 with 15 claims. The European Search Report was published in August 2020. During examination, the applicant submitted an amended set of 16 claims. On December 12, 2021, the examining division issued a Rule 71.3 EPC communication, stating its intent to grant the patent based on these claims. Now, applicant B notices a spelling mistake in one of the claims, a minor, obvious error. The applicant also wants the patent to be granted as soon as possible and take effect in the Netherlands. What steps should be taken and by when? Concept breakdown.
A correction request falls under Rule 139 EPC, but filing it triggers Rule 71 EPC, restarting the grant process. If the applicant wants to speed up grant, they should immediately approve the proposed text after receiving the second Rule 71.3 communication. Additionally, the 4th-year renewal fee must be paid if it wasn't already. To have the patent take effect in the Netherlands, a Dutch translation of the claims must be filed within 3 months of grant publication.
Reflection.
Strategic decision-making is essential here. If speed is the priority, requesting correction before approving grant might not be the best option. It could cause delays. Anticipating the administrative effects of procedural choices is key in patent practice.
Question 3. Supplementary search for a PCT application. Scenario. A Chinese company filed an International PCT application, PCTC, in May 2020 with the Chinese Patent Office. The application, written in English, did not claim priority. It contained one claim, which covered subject matter C1. However, the description also disclosed a second invention, C2, which is not linked to C1 by a general inventive concept. The office conducted the international search report, but only for C1. Now, Company C wants a supplementary international search by the EPO. What steps must be taken? Can the search report cover C2? If the application enters the European phase, can C switch to C2 for examination? Concept breakdown.
SISR only covers what was in the claims at filing. Since C2 wasn't in the claims, it cannot be searched under SISR. However, C2 can still be examined later in Europe under Rule 164.2 EPC, but only if an additional search fee is paid. This is a two-step process. Amend the claims to include C2 upon entry into the European phase. Pay the additional search fee when invited by the EPO.
Reflection.
The international phase sets the groundwork, but flexibility in the European phase allows applicants to adjust strategies. If an invention was described but not searched, there's still a way to get protection.
Question 4. Sufficiency of disclosure and novelty. Scenario. Applicant D filed European application EPD1 in January 2019, which disclosed a new raw material D1 and a method to obtain it. However, EPD1 was withdrawn before publication. Later, in March 2019, applicant D filed EPD2, which describes a method to produce a new product D2 starting from raw material D1, but doesn't teach how to make D1. Then, in February 2020, applicant D filed EPD3, claiming priority from EPD2. EPD3 describes the same method for making D2, but now using raw material D3, which was already publicly known. Meanwhile, another applicant filed EPD4 in January 2020 before EPD3, but it was published later in July 2021. EPD4 discloses product D2 and the same method using D3. Now, the question: A. Is EPD2's disclosure of product D2 sufficient? B. Is the claim to D2 in EPD3 novel? Concept breakdown.
Sufficiency of disclosure means the invention must be reproducible. Since EPD1 was withdrawn and not public, the method to obtain D1 is unknown. Thus, EPD2 fails sufficiency under Article 83 EPC. EPD3 lacks novelty over EPD4, which was filed first. Even though EPD4 was published later, it's still prior art under Article 54.3 EPC.
Reflection.
A well-planned patent strategy should ensure that all required information is disclosed in a way that satisfies both novelty and sufficiency of disclosure. If crucial details are missing, later applications could fail.
Question 5. Priority and novelty in a chemical composition. Scenario. On the 2nd of June 2020, Company E filed a European patent application, EPE, for a composition containing 5 to 40% of compound E1. EPE claims priority from a Japanese patent application, JPE, filed on 30 May 2019. However, JPE only disclosed a narrower range, 10 to 20% of E1. Now, the examiner has cited an article published in December 2017 that supposedly discloses a composition containing 40% of E1. But there's a catch. A skilled person would immediately recognize that the article contains an error. The only logical correction is 15% of E1, a value that falls within the 10 to 20% range of JPE. Now the question: does this article destroy the novelty of EPE? Concept breakdown.
First, we analyze priority. EPE was filed within the priority period, so parts of it may be entitled to the priority date of JPE. However, only the 10 to 20% range of E1 gets the priority date of 30 May 2019. The rest of the claimed range, 5 to 10% and 20 to 40%, gets the filing date of EPE of 2 June 2020. Now let's analyze novelty. The examiner's article was published in 2017, making it prior art under Article 54.2 EPC. If the skilled person would instantly recognize the error and identify 15% as the correct value, then the article is treated as if it had always disclosed 15% of E1. Since 15% is inside the 10 to 20% range, and this range is entitled to priority, the article does not destroy novelty under G393 and G115.
Reflection.
This case highlights the importance of priority claims and how errors in prior art can be corrected in novelty assessments. Just because a prior publication exists doesn't always mean it's novelty destroying. You have to look deeper.
Question 6. Opposition and appeal proceedings. Scenario: EPA was granted with 2 independent claims. Claim 1, Apparatus A1. Claim 2, Apparatus A2. Let's examine 2 separate opposition scenarios involving prior art document D1.
Situation 1. Opposition withdrawn.
A sole opponent filed an opposition based on D1, which is prior art under Article 54.3 EPC and only discloses A1. However, the opponent withdrew the opposition right after the opposition period ended. The question: A. Will the EPO continue the opposition proceedings? B. What should the patent proprietor do? Concept breakdown. Situation 1.
Even though the opponent withdrew, the opposition division has the power to continue proceedings ex officio under Article 114.1 and Rule 84.2 EPC. Since D1 destroys novelty for Claim 1, the opposition division is likely to proceed because limiting or revoking the patent doesn't require extra effort. The best strategy for the patent proprietor is to limit the patent to Claim 2 only to preserve as much protection as possible.
Situation 2. Appeal withdrawn.
The same opposition was rejected, so the sole opponent appealed and submitted D1.
Later, the opponent withdrew the appeal. Now the question: C. Will the EPO continue the appeal proceedings? D. What can the patent proprietor do to address the novelty issue? Concept breakdown. Situation 2.
Unlike opposition proceedings, appeal proceedings cannot continue ex officio. When the sole opponent withdraws the appeal is automatically terminated. The first instance decision becomes final. G893. Since opposition is no longer pending, the patent proprietor can request a limitation under Article 105 AEPC to remove Claim 1.
Reflection.
This case illustrates a major difference between opposition and appeal proceedings. Opposition proceedings can continue even after withdrawal if the case is strong. Appeal proceedings cannot. They end immediately. Strategic use of limitation can rescue a patent even after opposition has ended.
Outro. Let's reflect.
We covered some real-world scenarios today: re-establishment of rights, procedural strategy and examination, supplementary searches, and key principles like sufficiency and novelty. Patent law is all about timing, procedural choices, and strategic thinking. Understanding how these concepts interact will make you a stronger practitioner. Thank you for learning with me. I'll see you in the next session.